all think we own property, right? You know, houses, cars, maybe stocks, our digital music libraries.
Right. But legally speaking, defining what you actually own is way more complex than just having a deed or, holding something in your hand.
Okay.
That's really the heart of it. When lawyers talk about property, they're not just talking about the physical thing itself.
Hmm.
They mean a whole set of legally recognized relationships. Ownership, well, it's fundamentally this definable bundle of rights.
A bundle of rights, like what specifically?
The right to use it, the right to maybe sell it or give it away,
Yeah.
and maybe most importantly, the right to tell other people they can't use it, the right to exclude.
Gotcha. So our mission today is really to take you through these fundamental legal boxes, these classifications for that bundle.
Exactly.
We're going to look at, say, the difference between owning a copyright versus owning a carburetor
Yeah.
and figure out how a set of shelves can legally become part of a building
It happens.
and explore those really common situations where you might give something to someone else temporarily, give up possession, but you still actually own it.
And understanding these basic distinctions is tangible, intangible. Real property, personal property.
It's just critical because the law treats them differently. Different rules, different protections.
Okay, let's unpack this, starting with the absolute basics, the foundational definitions.
Right. So property can be broken down into two main types, tangible and intangible.
Tangible seems straightforward. That's the physical stuff.
That's what most people think of, yeah. Physical assets, things with actual form and substance. So land, buildings, cars, your clothes, anything you can actually physically touch.
Okay, but then we get to intangible. Here's where it gets really interesting. Because it's about value you can't physically hold.
Precisely. Intangible property is all the non-physical stuff. Things that can have immense value, but, like you said, you can't physically touch them.
So what falls into that category? Well, a huge area is intellectual property. We're talking patents, trademarks, copyrights, trade secrets.
Okay.
But it also includes things like financial instruments,
Yeah.
debts someone owes you, for instance, or even something more abstract, like a company's goodwill.
Company goodwill. That's a great example. For listeners who maybe haven't run into that in, say, business accounting, how would you define that legally? What is it?
Goodwill is essentially the value of a business's reputation and its established place in the market, kind of above and beyond the value of its physical assets.
So like brand recognition,
Absolutely.
customer loyalty.
Exactly. If you buy a really well-known brand, a big part of what you're paying for is that intangible goodwill. The customer base, the market standing. It's a real concept. It has real worth, even though you can't, put your hands on it, and the law protects it.
That distinction, physical versus non-physical, it forces us to think beyond just having something. I mean, should stealing a copyrighted song, something you can copy, infinitely be treated exactly the same legally as, say, stealing someone's wallet?
Well, that's the challenge, isn't it? It forces us to see that the legal system often tries to apply rules designed for physical things to these non-physical assets. But their nature is just fundamentally different.
Right.
Taking a song doesn't remove the original, but it definitely hurts the owner's right to control how it's used, how it's sold. The core legal idea protecting the right is still there, but the solutions, the enforcement methods, they have to adapt for assets that aren't, finite like a wallet is.
Yeah, and figuring out how to value and protect that non-physical stuff, that feels like the cutting edge of property law right now.
It really is. Now, okay, zooming back into the physical world for a moment. A classification gets even more specific. Tangible property. It's broken down into real property and personal property.
Okay, real and personal. Real property is land.
Land and basically anything permanently attached to it. Buildings, for example.
And personal property is just everything else.
Pretty much. Everything other than real property. Cars, furniture, computers, jewelry.
So if I buy a plot of land, that's real property. If I buy kitchen cabinets sitting in a box at the store, that's personal property.
Correct. But what happens when you take those cabinets and install them into the house on that land?
Okay, this is where it gets tricky.
This is where we get the concept of the fixture. A fixture is something that started as personal property.
Like the cabinets in the box.
Right. But it gets legally converted into real property because it's physically attached, that's physical annexation attached to or closely associated with the land or buildings, and, crucially, with the intention that it becomes permanent.
That idea of intent and permanence seems key. And this concept is huge in business, right? Let's use that specific example from the sources. Imagine a business owner. Let's call her Megan. She buys a big warehouse for $1 million. That warehouse is real property.
Definitely real property. Then, to make the most of the space, she buys $200,000 worth of heavy-duty steel shelving units.
Okay, initially, those shelves are personal property, just equipment.
Correct. But here's the critical part. She doesn't just, set them on the floor. These shelves are anchored down, drilled into the concrete foundation with heavy steel bolts.
Ah, okay. That sounds pretty permanent.
It signals a clear intent for them to stay put. And because of that level of physical annexation, those shelves legally become a fixture.
Meaning they're now part of the real property, like the warehouse
But yeah,
itself.
exactly. They're legally one with the real property now, no longer separate personal property.
Wow. Okay, but wait. What if Megan financed those shelves separately? Maybe she got a loan specifically for that equipment. Do the creditors who lent her the money for the shelves, do they suddenly lose their claim on the shelves because they're now part of the building?
Well, that's where the real legal impact of this conversion shows up. Once personal property becomes a fixture, legally, it generally follows the ownership of the real property.
So if Megan sells the warehouse,
The new owner gets the shelves too. They're part of the package. And yes, for the lender who financed the shelves thinking they had equipment as collateral, it drastically changes their situation. Their security interest is now in something that's become part of the real estate, not easily movable personal property. The whole nature of the asset has fundamentally changed in the eyes of the law.
it's a total transformation based on how permanently it's attached. That really drives home the point that ownership isn't just about physically holding something, it's about the legal rights surrounding it.
Absolutely. Which brings us back perfectly to that bundle of rights idea we started with. Ownership of property is really defined by that bundle.
Okay, let's detail that bundle a bit more. What rights are usually in there?
Well, the absolute core right, the one that really defines ownership, is the right to exclude others.
To keep people away.
Yes. If you can't legally stop others from using it, do you really own it? Probably not. But the bundle also typically includes the right to possess it yourself, the right to use it, the right to transfer it, sell it, gift it, and the right to commercialize it, to make money from it.
Right, makes sense. And crucially, the sources really stress that these rights don't just exist naturally. They're created and, importantly, enforced by the government.
That's absolutely correct. Ownership fundamentally depends on legal recognition. Governments create systems, think property deeds, patent filings, copyright registration systems of recording and disclosure.
To put everyone else on notice about who owns what.
Exactly. The government's role is essential because imagine a world without that legal framework and enforcement. Ownership would just mean, well, whatever you could grab and hold on to, probably through force or threat.
Not a very stable system.
Not at all.
So if the government grants these rights, it also means the government can limit them, even if you've paid for the property fair and square. This comes up in that really interesting scenario about Susie and the radioactive material.
Ah, yes, that's a perfect illustration. So Susie is entrepreneurial. She develops and patents a new process. Then she builds a machine to actually synthesize some kind of radioactive material using her patented process.
So she's created both intangible property, the patent itself,
Right, the legal right to the process.
and tangible property, the machine she built, and the actual material she produces.
Correct. She owns both. But then, maybe shortly after she's invested all this time and money, the federal government steps in and passes a regulation that prohibits anyone from producing or using that specific radioactive material, maybe for safety reasons or national security.
Oh, so what happens to Susie's ownership?
Well, this raises an important question. Despite her valid patent, despite her investment in the machine and materials, her recognized rights of ownership, specifically her right to use the material and her right to commercialize it, to sell it, have just been significantly limited or maybe even completely stripped away by government action.
Even though she owns the patent and the machine.
Exactly. Her ownership wasn't absolute. It was always conditional on the legal and regulatory framework that recognized those rights in the first place. And that framework can change.
Really hammers home that ownership is more like a legal relationship, maybe even a revocable one, not just a physical fact.
Precisely. It's defined and limited by law.
Okay, so that covers how we define ownership itself. But what about all those times we give up control over something, but we definitely still own it? Let's talk about bailment.
Ah, bailment. This is probably one of the most common legal relationships people enter into, often without even realizing it has a legal name. A bailment happens when the owner of some personal property, we call them the bailer, gives that property to another person, the bailee, for a specific temporary purpose.
So the bailee has physical possession.
Yes, they have possession, but, and this is key, the bailiff keeps the legal title, the ownership.
And this can be a formal express agreement, right? Like hiring a moving company to transport your furniture or checking your code at a restaurant.
Exactly. Those are express bailments. You're intentionally handing over your property for a specific service.
Mm.
Or, another example, if Alex asks his friend Brandy to sell his car for him on commission.
Okay.
Alex is the bailer, Brandy's the bailee. While Brandy has the car, she has a legal duty to take reasonable care of it even though she doesn't own it. That's an express bailment.
That duty of care, the liability aspect, that's really important. But what about accidental situations? The sources call them implied bailments, like Gary leaves his laptop at Dina's house by mistake.
Right. That's not an intentional handover. But the moment Dina finds it and agrees, even implicitly, just to hold on to it until Gary can come back for it.
An implied bailment is created, just like that.
Just like that. Dina has taken temporary possession.
Yeah.
And with that possession comes a legal responsibility. The duty of a bailee to safeguard Gary's computer until he retrieves it.
Wow. Okay, the sources give a really relatable scenario here to test this. Rhonda's leaving a busy restaurant, grabs a coat from the rack, gets home, and realizes, oops, it's not her coat. It looks similar, but it belongs to someone else. She decides she'll just return it the next day. What's her legal position overnight?
Okay, so Rhonda is now in possession of what the law might call mislaid property. The moment she realizes the mistake and decides to hold on to it with the intention of returning it,
She becomes a bailee.
she assumes the legal status of an implied bailee. Yes. This legal relationship is created purely by her having possession and knowing it's not hers. It doesn't matter if she or the actual coat owner consciously thought, we are now entering a bailment.
Huh.
Her possession creates the duty.
Yeah.
She's now legally obligated to exercise reasonable care to protect that coat until she can get it back to its rightful owner or the restaurant.
That's fascinating. It just happens based on the situation. So what does this all mean? We've kind of cut through a lot of the complexity in property law today.
We covered some ground.
Yeah, we established property isn't just physical things. It includes those abstract concepts like goodwill, patents, copyrights.
Right, the intangible side.
We analyzed the really critical differences between personal property and real property. And crucially, how something can legally change from one to the other by becoming a fixture, like those bolted down shelves.
And we reinforce that ownership itself is defined by that bundle of rights, especially the right to exclude others. And importantly, that those rights aren't absolute. They're conditional on government recognition and can be limited by regulation, like poor Susie and her machine.
Right. And finally, we looked at how incredibly common bailments are these situations where ownership and possession get temporarily split, creating immediate legal duties for the person holding the property, the bailee, whether they intended it or not, like Rhonda with the wrong coat.
And really, our whole discussion today underscores that legal ownership, especially for significant assets, relies heavily on formal, recognized legal status. Which brings us back to the need for that legal recognition, particularly with real property, with land. Think back to that practice question scenario about Gordon and Winona. Gordon makes a verbal deal to buy Winona's land. He pays her the money, he even moves onto the land and starts using it, takes possession.
Okay. Seems like he owns it.
But they never signed a formal deed. They never legally recorded the transfer. Then Winona passes away, and her children look at the official records and say, hey, Mom still legally owned that land. It's ours now, part of her estate.
Oh, wow. So Gordon's paid and he's living there, but legally.
Legally, it's shaky. What does that situation really teach you about needing that formal legal recognition like a deed versus just having physical possessions, especially for land?
It teaches you that possession isn't always 9/10 of the law, I guess, especially not with real estate.
Exactly. Possession, even with payment and acting in good faith, often isn't enough when it comes to real property. Because the government has these established formal systems for recording ownership, the lack of that recorded deed means Gordon might have a claim for his money back, maybe a contract dispute, but the actual legal title to the land, it likely stays with Winona's estate according to the records. The formal government-recognized system trumps just being there.
That's a really powerful reminder. When it comes to property, especially valuable property, the law cares less about what you're holding in your hand and much more about what's written down and officially recorded. We'd definitely encourage you to think about how these kinds of legal lines and categories apply, maybe even to the digital stuff or shared assets you use every single day.